Welcome back to the deep dive. There's that very specific feeling you get when you finally decide to do a serious spring cleaning.
Oh, I know that feeling. You're standing in front of a closet that's just been mocking you for years.
Exactly. And you say, today's the day. We're going to streamline this. We're going to make it efficient.
It feels great until, of course, you realize you threw out your passport in the process of optimizing the filing cabinet.
That is the perfect analogy for what we're looking at today, this tension. Because the European Commission is doing a massive spring cleaning of its own.
They're calling it the digital omnibus.
Right, and the pitch is exactly that vibe. Let's update the GDPR and AI privacy rules. Let's make them leaner, better for the digital economy.
Which, on the surface, sounds totally necessary. I mean, the tech world moves incredibly fast. AI is a different beast now than when the GDPR was drafted, so a refresh makes sense.
But we aren't just reading the Commission's press release today, are we? We're looking at a blistering analysis from NOIB.
Right. NOIB, none of your business. The privacy group founded by Max Schrems.
And if you follow this space, you know that when Max Schrems shows up, it's not usually to compliment the drapes.
No. If NOIB releases a report this big, it's because they've found a fire. And they argue that under this guise of simplification, the Commission is drilling holes in the hull of the GDPR.
They don't call it a spring cleaning. They call it a fundamental departure from our privacy rights.
We're talking about redefining what personal data even means, creating new carve-outs for AI, and just changing how the internet works for everyone.
So our mission today is to unpack this. Is the digital omnibus a real upgrade for a modern web, or is it a stealth downgrade of our rights?
And before we get into the weeds, and we will, it's worth remembering that navigating privacy is already a minefield, especially for younger people.
It really is. That's why we want to take a moment to mention www.childrenprivacylaws.com if you're building anything for kids or just a parent trying to understand the protections that are in place right now.
Before they all potentially shift under our feet.
Exactly. It's an incredible resource for the current lay of the land, because that baseline, as we're about to see, is what's up for debate.
Okay, so let's start at ground zero, the absolute bedrock.
Personal data, Article 4.1.
This is the atom of the privacy universe. Everything rests on this.
And I think for most people, it's binary. If a company has a spreadsheet with my name, my email, that's personal data. But NOIB is saying the Commission wants to change that.
This is maybe the most subtle but dangerous shift in the whole proposal. Right now, the GDPR uses what we'd call an objective standard. Meaning the question isn't what the company wants to do. The question is just, can this person be identified?
By anyone.
Essentially, yes. If the data allows you to be singled out using reasonable means, it's personal data. The capacity to identify you exists. That's what matters.
Okay, so if a telco has my GPS pings, even if they strip my name off, it's still personal data because they could reattach it from another database.
Precisely. The potential is there, so the data is protected. But this new proposal wants to shift that to a subjective standard.
A subjective one?
Yes. The text says information is not personal data for a specific entity if that entity can't identify the person.
Wait, for a specific entity? So data could be personal for one company, but not for another?
Exactly. And NOIB argues this introduces intent. If a company says, look, we have this data, but we don't intend to identify anyone, and it would be really hard for us to do so, then suddenly the GDPR might not apply to them.
That feels like a massive loophole. You're letting the company decide if the law applies based on their own internal policies.
That is the critique, 100%. It's what the report calls the pseudonymization loophole.
Okay, walk me through that.
Let's say a big tech platform takes your entire browsing history and just replaces your name with user 9988877.
Which is standard practice. We want that.
We do. But then they put the file that links user 9988877 to you on a separate server, maybe in a different legal entity.
Ah, I see where this is going.
The team analyzing your behavior can now argue, hey, we can't see the name. For us, this isn't personal data.
Even though they're still building a profile on me, targeting me with ads, manipulating my feed.
Exactly. They can claim it's all anonymous processing, so the GDPR doesn't apply. It destroys the concept of protection by design.
It's like a semantic trick. It treats the name as the only thing that matters, not the person.
And the report points to a real-world case in Austria, the telco tracking issue.
Oh, right, where the mobile providers argued location data wasn't personal. That was wild.
Their argument was so slippery. They said, we track the SIM card, not the person. Maybe the subscriber lent their phone to a friend. We can't be 100% sure.
That's absurd. My phone is basically attached to me. It's got my fingerprint lock.
The DPA rejected it back then, but Noib worries this new language would actually validate that defense. It opens the door for so many excuses.
And there was another case, the NOAC case, about an exam paper.
A classic. A trainee accountant failed an exam and wanted to see his answers. The examiner said no, arguing his answers weren't personal data.
But the exam result determines his entire career.
And the court agreed. It relates to him, his knowledge, his future. So it is personal data. The fear is this new proposal reverses that logic.
Because it's too focused on the technical ability to find a name, not the real-world impact on a person.
Precisely. It puts the company's convenience above the individual's rights. And that theme, well, it runs through the whole document.
Let's talk about scientific research. I mean, who doesn't like science?
Right. But definitions matter. The Commission wants to create these broad exemptions for research. So maybe you don't need the same level of consent or the same purpose limitations.
Purpose limitation being, if I give you my data for a pizza delivery, you can't use it to train a drone.
Unless you call that drone training research into autonomous navigation. That's the problem. Scientific research isn't strictly defined.
So a social media company A/B testing ad colors could just call it behavioral science research.
And suddenly they might not need your consent. It's a catch-all. It blurs the line between public interest research and just commercial R&D.
And speaking of excuses, the part on transparency was something else. The part about when a company has to tell you what they're doing.
Article 13, the Simplify the Paperwork section.
It says companies don't have to inform you if it's a disproportionate effort or if the activity is not data intensive.
Not data intensive. What does that even mean?
The company gets to decide, I guess.
And that's the trap. Noib uses themselves as an example. They have a newsletter with about 25,000 subscribers.
So is that data intensive?
Who knows? And Noib says they don't know. Under the simplified law, they'd have to guess. And if they guess wrong, they're facing a fine of up to 20 million euros.
So simplification actually creates legal chaos for the small businesses it's supposed to help.
Exactly. They can't afford the lawyers to interpret these vague terms.
Which is a crucial point. If you're running a business, you can't just guess.
No, you really can't.
And that's where a resource like privacyrights.compliancehub.wiki becomes so important. When you're staring at a term like legitimate interest or data intensive, you need a resource that shows you how it's actually being interpreted.
It's essential. You don't want your company to be the test case for a 20 million euro fine.
Absolutely. So check out privacyrights.compliancehub.wiki. Now, let's pivot to the one thing every internet user hates with a burning passion.
Cookie banners.
The proposal claims to fix them. Please, give me some good news.
Okay, there is some good news here. Article 88B, it pushes for automated signals.
This is like global privacy control.
Exactly. Instead of clicking reject on every single site, you flip one master switch in your browser that says no tracking, and legally, every site has to respect it.
No more pop-ups. That sounds like heaven.
In theory, yes.
Okay, I hear a but coming. What's the catch?
The catch is a big one. An exemption for media service providers.
Wait, so I can tell my browser no tracking, and an online store has to listen, but a news site doesn't.
That's the proposal. The idea is to protect their economic basis, since they rely on ad revenue. But Noib says this creates a huge equality before the law issue.
It feels totally unfair. If I say no, I mean no. Why does a news site get to ignore my choice?
It defeats the whole purpose of the automated signal, and that theme of special exceptions gets even darker when we get to Article 88A, device integrity.
This was the security scanning part.
Right. It allows access to your phone or laptop without consent if it's for maintaining security.
Which sounds fine. I want my computer to be secure.
But look at the example Noib uses.
Yeah.
Anti-cheat software for video games. Some of this stuff is incredibly invasive. It scans your entire hard drive.
Yeah, some of them are basically rootkits. They can see my photos, my tax documents, everything.
And Noib argues these new rules could make that legal. Your right to privacy on your own device could be overridden to protect a game's virtual economy.
That is just creepy. It's prioritizing the company's security over my own.
It's the pattern. Simplification for them, complications for us. And I think that pattern really peaks with the biggest buzzword there is,
AI.
the so-called AI privilege.
Before we get into that, I do want to give a nod to biometric.myprivacy.blog, because we talk about AI training on text, but it's also training on faces, voices, the way we walk.
It's a huge blind spot. That biometric data is being vacuumed up constantly. If you want to understand the specific risks, how your face could end up in a system you never consented to, that blog is the place to start.
A great point. So the AI privilege, Article 8018, this is where NOIB really takes the gloves off.
The proposal suggests that AI developers can rely on legitimate interest to train their models instead of consent.
And legitimate interest is usually the weakest legal basis, right?
It's a balancing act, and you can usually object, but for AI, it's irreversible because of the black box problem.
The report had that great baking analogy.
Yes. Training an AI is like baking a cake. Your personal data is the flour, the eggs, the sugar. Once the cake is baked, you can't get the flour back out.
So if I later decide I don't want my data in their AI, they can just say, sorry, it's technically impossible.
And this proposal seems to accept that excuse. It effectively gives AI developers a pass on the right to erasure. If a hospital messes up your record, they have to fix it. If an AI digests your data, they might not have to.
And it's not just about privacy, it's about truth. The report mentioned AI hallucinations.
This is the nightmare scenario. There are cases where chatbots have just made things up and accused innocent people of horrible crimes.
So you could Google yourself, and an AI summary might say you're a convicted felon.
And under these rules, if the company claims it's too hard to fix their black box model, you might have no legal remedy. You have a machine defaming you, and the law just shrugs.
That is terrifying. We're stripping away fundamental rights just to make life easier for AI developers.
And that's the core question Noib is asking. Are we simplifying the law for people? Or are we just simplifying the compliance burden for big tech?
It's like hiring a cleaner who just throws out all your furniture because it's too hard to dust around it.
That's a perfect way to put it. We cleaned the room by emptying it.
So let's bring this all home. The Commission says efficiency. NOIB says it's a rollback of rights. What's the big takeaway?
The tension is economic utility versus individual rights. The Commission wants European tech to compete. NOIB is arguing that the rules they want to loosen are the only thing standing between us and total digital surveillance.
It's not just legal text. It's about whether your location data is actually yours. It's about whether you have the right to say no to a news site that wants to track you.
And whether you have any recourse when an AI gets your life story completely wrong.
Here's the thought I want to leave you with. If a company claims they can't identify you to get around the GDPR, but they can still use that same data to target you with ads to influence your vote, have we actually simplified anything?
Or have we just legalized a massive blind spot? If they can manipulate you, does it even matter if they know your first name?
Something to think about. You can find links to the NOIB report and our sponsors in the show notes. That's www.childrenprivacylaws.com, privacyrights.compliancehub.wiki, and biometric.myprivacy.blog.
Stay curious and stay critical.
See you in the next deep dive.